Good morning, everyone. On behalf of the Bar Council of Punjab and Haryana, Vidhi Talks, I, Nidhi Sharma, advocate, welcome you all to an interactive session on the topic, the art of reading and applying judgments. Our esteemed guest for the day is Honorable Mr. Justice Vikas Bahl. He is sitting judge of the Honorable Punjab and Haryana High Court at Chandigarh. And the topic for today, as I mentioned, would be the art of reading and applying judgments to your case. So we also have the team for today, which comprises of members of the fraternity, Mr. Jashan, Ms. Akriti, Ms. Sanigdha, Mr. Bhavish, and Ms. Diksha. So before we begin with the session, I would like to briefly introduce our esteemed member, our esteemed chair for the day, Honorable Mr. Justice Vikas Bahl. Coming from an illustrious legal background, Justice Bahl epitomizes the true brilliance of a High Court judge. He is somebody who starts working at 4 a.m. in the morning and somebody who never takes an off. His brilliance is writ large in his judgments and the way he conducts himself. He has not only adorned the dais with his brilliance, but has also been a very illustrious lawyer. So, we thank you, sir, for culling out your precious time for us, for sharing your insights with us. And I request you to please share your pearls of wisdom with us on the topic, the art of reading and applying judgments to your case.
Thank you so much to my younger sister. She's been very kind with her words. Today's topic, in fact, I can come straight to that, is something which is very close to my heart. And why I say that is, and I'm very happy that all my younger colleagues are sitting here, who are, although in some years into practice, but I see them, they are fresh faces and they are going to move forward in life. And so therefore, what I understand once one wants to become into active practice, the two most important things that we need to really inculcate, and if you're able to develop that, obviously we develop it over a period of time, it doesn't happen in a day. But if we have a way of moving forward in those, then there would be a time that you will feel so confident about, presenting your case and maybe able to carry forward your point. So one is obviously preparation in a matter. The other is reading a judgment and then applying it to your case. And now once on this side also one is here. So one does see that, if some kind of a push is given to some of our younger colleagues, it might just help them a lot in the long way. Reading judgments, everybody, at the time when you become a lawyer, you have moved out from a student's life. So there is a big difference. As a student, when you read a judgment, maybe you need to bug it up a little bit. You need to cramp up certain part of the judgment so that if you have to write it in your exam, maybe you have to reproduce some part of the judgment, maybe you have to write. Now, when you read a judgment as a professional, or for that matter as a person who has to adjudicate, the entire focus on the judgment should be to understand the judgment, not to learn the judgment. Because when you are dealing with actual cases, when you are dealing with the cases, whether you have to put across your point or you have to adjudicate a case, you have to understand the judgment, because it is the judgment which you have to apply to the facts of a different case. It is not that somebody will ask you to stand up and tell the public or anybody where you are speaking or where you are addressing to tell what the judgment says. It is that you have a particular case with you in your hand, you have read the case and you have to apply that judgment to the facts and circumstances of your case. So the first thing that I would want to really request everybody is that when you are reading a judgment, please understand the judgment so that you can apply it in different facts, different situations, and whether you find that, whether in a particular situation would be relevant or not, all those things you need to understand. So now judgment reading and judgment applying, broadly, categorizing it, one would feel that there would be judgments which would be laying down law. There would be some judgments which are maybe constitutional bench judgments from the Supreme Court, maybe judgments of our High Court, maybe reference judgments, which would be judgments which would lay down law and on a particular subject, maybe for that period, be authoritative judgments. And there would be other judgments which would be on some fact situation, some issues which you will face in everyday proceedings, maybe in Order 6 Rule 17 for amendments to be carried out, maybe for additional evidence. So some such aspects which may not be path-breaking judgments, but which will be judgments which one would need to apply and use in a daily, daily matters coming up. So one would want to start with the second kind of judgments as to how one can go about, and how out of my experience I can say that how I used to apply these judgments, how I used to use these judgments, and ultimately over a period of time one was able to really understand as to when to apply, how to apply, and whether a particular judgment does apply or not. So as I told you, you start off with the fact that you need to understand a judgment instead of learning it by heart, learning a paragraph by heart. We don't need to do that. To apply a judgment, and why I start with this is because as youngsters, maybe you will not get matters which are very, very heavy matters. I'm talking on the civil side now, for which we have a lot of work in the High Court. And presently I'm also holding that roster on the civil side. So on the civil side, maybe you get some kind of an interim revision. As I mentioned about amendment revisions, as I mentioned about evidence being closed, etc. So these are the kind of cases which normally youngsters, 6-7 years into practice, from the beginning till around 6 years, would normally get to argue. Now in that situation, what you need to really do is, firstly you need to understand your case thoroughly. You need to you need to read the whole case, every fact, every document that you have with you. You need to read that first before applying a case, before applying a judgment. Once you're able to read your facts of the case, the entire evidence, whatever plain written statement and everything, and apply your lucrative mind in understanding as to what all points you can develop. In most of these cases, there will be an impugn order. So once there's an impugn order, you read through the impugn order, you should know the reason why your case has been rejected. Once you know that your case has been rejected for a particular reason, then in order to be successful, you have to come over that reason. You have to, from the facts of that case, as well as the law which you will ultimately try to find out, be able to overcome that point which has been taken against you in passing the impugn order. So the best way forward is that before you start finding law on the point, read every word of the impugn order, read the plaint, read the written statement. If there is evidence with you, read the evidence, and then call out a point. If it's been rejected, like a case of, I'll again go back to an amendment because you have to exemplify so that it becomes a little more, you can understand it better. Assuming it has been rejected on the point that it is delayed, there is no due diligence. So now, as far as due diligence is concerned, they say that you have come after the issues have been framed and you have come after the evidence have been led. And this particular piece of amendment, this particular piece, what you're wanting to bring in was in your knowledge prior to the issues being framed. So you know this is the point that you're looking for. Once you have seen everything now in that, so many relevant factors need to be considered. Some people would just think that let me find out something from the laptop saying that even if it is belated, then also amendment should be allowed. Don't leave it at that. See whether you are in possession or not. See whether you are the plaintiff or the defendant. If you are a plaintiff, you are not in possession, then there is a slightly point in your favor because delay would not help, harm the other side. It might just harm you more. Then as to whether it is necessary or not. If it is necessary, how necessary it is. Now that day somebody, a very, very good lawyer, was arguing a matter. So he pointed out that I want to make an amendment with respect to some earlier Jamabandis. So the relevant factor was the Jamabandis were relevant, but the Jamabandis which were already on record also reflected the same thing. So whether then he needed to add those Jamabandis, what was the real reason for adding those Jamabandis which were a little prior in time, when you already had the Jamabandis mentioning that same fact. So therefore you need to really understand your case as well as you possibly can. After having read the whole case, then you need to start searching the law. Invariably, in the impugn order itself, there will be some judgment mentioned against you, some judgment mentioned in your favor, maybe by your counsel and maybe by the court while rejecting your case. Immediately take out those judgments also. Before that, there is another prelim that you need to do. Just find out as to what is the most acceptable citation. In today's time, I can say that as far as the Supreme Court is concerned, the SEC is the most acceptable citation. We see a lot of people finding it from various portals, etc., which may not be the best way to cite it because the paragraphs are different and everything is different. So obviously subject to, whether you have that SEC online, etc. But in case you have an option, so you go in for SEC online. So obviously the first endeavor is always to find a Supreme Court judgment on a point. The second endeavor is to find something from your own court. And the moment you are looking for some law or something, and you're looking for a particular point because now that thing is in your mind, you're able to lay down your hand on 3-4 judgments. And then you can, obviously, the moment you see the catchwords are fine, and it looks to be maybe from the head note, maybe for wherever, then you take out a print of those judgments. Once you've taken out the print and you find that there are 3 judgments, 2 may be coming from the impugned order and 3 that you have found out, first go with the Supreme Court. Always read the Supreme Court first, and from the best, SEC, as I told you, would be the most acceptable. Always make it a point that you read it from that, instead of, first reading it from somewhere and then going into SEC and then wasting your energy and time on that. If you find that the first Supreme Court is there, now while reading the Supreme Court, once you find that this seems to be a little relevant from the catchwords or from wherever, whichever way you find it, then you need to hold a red pen and a blue pen. Because that is my request to everybody. I find that a lot of judgments which are being cited in court, maybe the catchwords are fine, but when it is applied in your own case, it is completely irrelevant or it is against you. So that wastes the time, and that, ultimately doesn't carry forward your case also. So when you are reading that judgment, you would have a blue pen in your with you, and you have a red pen also. I saw some other senior working like that, so I've been doing that all my life. The blue pen would be for underlining those facts. Firstly, get into the habit of reading the whole judgment. Don't just read the relevant paragraphs. Read the whole judgment once you find that it looks to be a little relevant to your case. Now, with a blue pen, you underline all those paragraphs, all those lines, all those facts, which you feel that would further your case when compared to the case which you are dealing with. I will exemplify that. Red pen you can keep on underlining and using, which you feel is going to be distinguishable, maybe by the other side if they get the judgment, or maybe when the judge gets to read the judgment. So, one case, one point, you have studied the entire facts of the case, you know what are your highlighting factors, and then you have marked the judgment with a blue pen, whatever you feel you can highlight and show it, and whatever is in your favor, and with a red pen, whatever would be against you. Now, to give an easier example to you, because maybe civil would be a little more intricate. Now, assuming it's a case of an amendment, assuming it's an admission matter. Let's talk about an admission matter. That's a simple, because there are simpler facts that you will be able to understand. What you are asking for admission being given to your client, who's a student in some university or maybe some college. Now, what you've been able to cull out as facts from your case is that the child is got 80% marks. So that is a highlighting factor. The second is that the attendance is 70%. And there is some issue that there is some kind of an FIR against the child. And you have to project the case that he should be given admission or he should be permitted to sit in the exams. So now you are wanting to support that by some law. Now, assuming you are able to find some judgment which you feel that is a little relevant on the, how do you start reading the judgment? You obviously start reading from the first paragraph. Now, the moment a point comes that the child in that case has got 79%. So what will you do? You use a blue pen or a red pen? Blue pen. So you use a blue pen. It may not be a highlighting factor in that case. But while comparing your case with that case, it becomes a highlighting factor because somebody who's got 79% marks was ultimately also got admission. So, as you move forward, assuming that person has 71% attendance, then obviously you need to use the red pen. So, you are just reading through the judgment, and then there is a conviction of that person. Again, you need to use the blue pen. Conviction in his case. See, now this is where I wanted to, and I'm very happy that you brought this up. 95% people or youngsters, when they are citing a judgment, or even I would say at a experience stage also, they always feel that they are arguing that case. The judgment which you have found out, it's not that judgment you are arguing. You're not arguing for the Supreme Court against that judgment. that you are trying to hide that he's got a conviction. You are trying to show that in your case, the man only had an FIR, whereas in that case he has a conviction, and still he won the case. So whenever there is a comparison being drawn, whenever you're trying to apply a judgment in your case, once you know the facts of your case, invariably bring out the negative points of the same person on the same side, assuming you're arguing for a student. Bring out the negative of that student in the other case to highlight that even those, in spite of those negatives, still he won. So that's how you apply the judgment in your case. There's somebody, in the beginning who joined my office, a brilliant youngster. He would always project the good parts of that student. And he was surprised when I told him that you're just doing the opposite. So he was very surprised. He said, sir, this is when you were telling me to... He used to always mark the argument of the counsel for the student in that case. Whereas I told him, mark the argument of the university counsel in that case. Is that one paragraph of the university counsel, the opposite as you would say it, who would bring out the worst in that case against the student in that case, which will help you a lot. Because that student will say he is not regular, he is mischievous. The lawyer will argue something or the other, which would be against the petitioner in that case. So if you are able to mark that with blue, and then highlight that, and then show that still the man won the case. So that would be the best point for you to put across. That is the presentation. That will come a little later. The student's lawyer, he will argue the best points of that student. If you are a university lawyer in this case, then possibly you need to read that. Because what he'll say is, he's been very regular. He's a very good student. He's got even he takes parts in declamation also. That's what his lawyer will argue. So that will be the distinguishing. Now that is subsequently coming on the presentation. First you have to be fair to the court and to yourself to understand whether the judgment is good enough or not. Now coming back to the fact that whether you want to know how the judgment is relevant or not. Once you've read through the judgment, so you have your blue marking and your red marking to tell yourself as to, you got a blue marking, he's got 79%, you've got 80%. So that's a point in your favor. That's a point in your client's favor. He's got 71% attendance, you have 70, that's a point against you. That's how you distinguish judgments. And then a third factor, that there is a conviction, which is a much point in your favor because you only have an FIR against you. So you have underlined all that. Now before you think of presenting that judgment, think about the whole effect of it. Now you know the policy, how much time goes into reading a judgment. And if you're able to cite here, people bring in 10 judgments in one case. It's not possible. With great difficulty, you'll be able to find one which fully applies and which helps you. And one is enough. If to get a notice of motion or to win a matter, ultimately, maybe that one is enough. Don't cite 10 judgments, don't cite 50 judgments. It's the most irritable thing that one can do. So now, once you're able to find out, then sit back for 2 minutes, cull out the top points. What I used to do is, I used to write down on the first page whatever is in favor and whatever is against. Because if I found a judgment on a point, that should stay with me for all life. It's not that I'm reading a judgment only for one day for tomorrow's matter. So then that one judgment now it will stick in my mind and say, okay, if a person has so much percentage, if I have, God knows how many more matters I'm going to get in the same issue. But I should know the relevant factors in that case. Judgments are never passed in some kind of an abstract. These kind of judgments are given on the basis of the facts of every case. So if you will de-link yourself from the facts of the case and just go by last paragraph, the student should be normally given admission, that's generalizing the whole thing. So that's how you need to really understand a judgment. And when you have been able to pluck out the important parts and you feel that no, 3-4 things are in my favor, although this one thing is against me, but reading the whole judgment, I'll be able to carry forward the judgment and it's a judgment in my favor, then please keep it as a judgment in your favor. Similarly, when you go to another judgment, and what I used to do is that once I found a judgment, I used to keep it in my lap or maybe keep it on the table. Then you find another judgment, maybe of a division bench, and you again assess it with a blue pen and red pen. Read the whole judgment with a blue pen and red pen. Read every line, because one line, one fact can make a judgment irrelevant. It can make a judgment completely against you. One factor. This is what you need to understand. The moment you find that, just exclude the judgment. Don't cite it just because you found it. Because that's where you irritate the court, you waste the time of the court, and you end up losing also. So the moment you find that there's maybe there's some such factor, if that person has won, only judge says no, 80% is not enough. In that judgment, supposing there is an observation which says 80% is not enough, 70% is also not enough, but because this man has taken part in declamations, and 20 of them, therefore we grant him the right to sit in the exam. Now, if you read the judgment not thoroughfare and you cite the judgment, thinking 80% BA, 70% BA, but actually the judgment is against you because you don't have 20%, 20 declamation contests that you're. So there's so many things have to be considered. One line in a judgment, I'm telling you, makes it so. Don't leave out even any line. And that's why I keep saying that you always win on the facts of your case by applying some judgment which applies to your case. So therefore, if you don't know the facts of your case, then where are you reading the judgments? Today you ultimately your aim is to solve your own case. You're not there to give a lecture on that judgment which you have read. So that's one way of going about it. Similarly, when you have to distinguish a judgment, there is nothing in this world you can't distinguish. Some people say, oh no, this judgment is against me. The same judgment which you cite in your favor in a particular case can be distinguished and therefore made either irrelevant or in fact against the person who's citing it. That I'll also tell you a little later. So once you have found one judgment, you found another judgment. Once you found the second judgment also, then spend another 5 minutes thinking as to whether the second judgment is better than the first or the first is better than the second. Decide there and then. That's how you need to present. We have seen people just passing off 5 judgments and then getting confused which one we have to cite. Once you found the second judgment on the point, at there and then you have to decide whether the first is better or the second is better. If you find that the second one is better, put it as first in your table. Mark it as first. And if you happen to find the third one, then decide there and then which one is the best. Now once you have found out 3 judgments, you find that no, this third one, take out the most relevant. One should be good enough in a matter. So this is the way, and then obviously then the next thing that you need to, I can tell you about the presentation also before I get to the second point. Presentation is becoming a big problem in most of the times, maybe lack of time, maybe thinking that the fee that has been paid is not that much, so it's not really worth it. Thinking that this would be good enough, the judge is intelligent. No, don't do that. As a lawyer, when you are coming to the court, nobody knows how much you've been paid in that case. It could be that you would not be paid anything, or it is that it is very minimal fee. But that is not what the question is. There are 50, 70 people at the back of the courts watching you. There will be 5, your client and some other clients also sitting. Then there is a judge, there is people around you, there's a reader of the court, there's everybody. So presentation of the case is 50% is preparation and 50% is. Now we have seen some youngsters, the moment they stand up, he will give a compilation to the judge with a front page on it, nicely mentioning for judgment number 1, judgment number 2, judgment number 3, flagging them 1, 2 and 3, and also having it for his own self, and now even for the opposing counsel. Now the moment you see such a lawyer, whether he's 2 years into practice, 3 years into practice, 5 years into practice, 7, you immediately you feel there is somebody who's here, who has come to do work. That's much of a difference it makes. And so some people, if you give it casually, there will be confusion. You will not be able to know which one to cite. Sometimes the judge will not be able to catch up which page you're wanting. So there will be a break in your argument. There will be little bit of annoyance also that things are not being properly presented, etc. So once you study the case properly, prepare it properly, because as a youngster you will have all the time in the world. I don't think so. With God bless that everybody should get as much work, but in the beginning it's not that you have had 20 cases in a day to argue. So you present that one properly, you leave an impression on everybody. And even the client feels that, this man is well prepared, so let me take the next case to him. Some friend will also come up, give you work, etc., etc., etc. Now, once you have cited a judgment, because you have analyzed it so well, it will stay in your mind. It will be something which you will understand because you have read every word of it. So that is what will add to your knowledge, which is an ongoing process. You will start understanding the intricate why for one reason a court decides against, why for one reason the court decides in your favor. And believe you me, slowly, when you do 10 or 12 matters, the moment you'll be about to read, it's a circle. Now you've read 4-5 judgments on the point, the moment the sixth case comes to you, you are not sitting with a blank plate. You immediately know, okay, if that is there, that's a point in my favor. I have that judgment. I have that judgment. Maybe you don't remember the name of the judgment, but you know that in that case I took it. Because you've understood the judgment so well. So the moment some student comes to you and he says, sir, I got 85%. Okay, you say, oh, that one. 85% is got. You start asking the relevant questions. That's how you build up. It doesn't happen on the first day. In the first case, it will never happen. And then second, okay, you got 60%. Oh, this is a point against. That judgment is against. So that's how you start becoming a lawyer. From a student, you start becoming a lawyer. And in the fourth, fifth case, you start feeling that you have a hold of it. You'll be able to bring out something because you read those judgments very, very thoroughly. At that time, don't think about the fact that whether you've not been paid adequate salary or maybe you're doing it for a senior. It is building up your knowledge on that point. On this, I can share with you. I used to get civil work in the beginning, and I used to get specific formants, RSAs. So the first one I used to do was I read one judgment, and I used to always look for that point because I knew no other point. In the beginning, laptops etc. weren't there when we started our profession. So there was one judgment which I got to read, and in that judgment there was a judgment referred to, which when I took out, I found it to be in our favor. So I used to always remember that one point, and I used to always look at for that point in the next case for specific formants. But in the second case, in the impugned judgment, there were 3-4 more referred. So I read them carefully with the red pen and the blue pen, and then there were 4 points I was looking for in the next case. In the next case, there were 2 more, so it added another 2 more. By the end of it, by the time I did my 20th RSA on specific formants, I knew that I can crack any case. I knew that I'll be able to get a judgment which will be apt for something or the other from the evidence I'll be able to find out. Because by that time, you have seen so many judgments so closely and understood them that you will be able to fix the facts of the case in some judgment or the other. So that's how you become a little bit of an expert. So that's how it rolls. On the other side, if you read things casually, if you just read the head notes, if you just read one factor, then apart from the fact that you will not understand it, you will not be able to apply it in your case, you will even go and maybe annoy the bench. Because you will give the judgment and the judge will find out there is something against you. You will not have an answer because you have not read the whole judgment. You have not understood the whole judgment. And whatever knowledge you will gain from that will be very temporary. In the next case again you will have to find fresh. You will have to start fresh. So my request to everybody is that whenever you want to apply a judgment in the case, understand the facts of that case to the last T. And then read the judgment with the red pen and a blue pen. Mark it for all life. And then store it in a manner. Assuming you have something on admission matters, please keep a file. You put all the admission matters judgments on one. You keep on the other side. You want to file, in fact, you want to divide it by saying favor or separate, students' favor, university's favor. Do that. If it takes another 10-15 minutes, it doesn't make a difference. Some people have, with a very, very good lawyer, is stored it in his phone. He keeps writing everything and he's there and then. So, now you will be able to understand as to how to apply. As a judge, we have to apply. We have to pass judgments which are doing justice to people. And as I told you, in an amendment case, now as a judge, I have to decide and I have to do justice to people. So I still remember there is a youngster. So the first thing we look at in an amendment of pleadings, is whether it is necessary or not. Now, so that's the principle that's a lot of Supreme Court has laid down. And then obviously with the proviso to Order 6 Rule 17 coming in, that if the issues have been framed, the trial has commenced. So something which you knew before the issues were framed, assuming there was an agreement in your favor, you knew about it and you never mentioned about it and prior to the issues. So therefore the proviso hits you. Now for a judge, he has to balance it. He has to balance between judgments which would say that a necessary amendment should be allowed, and also the fact that due diligence. So these are the two balancing factors which we have to apply. Now how do we apply it? And how would you apply it ultimately when you are given to adjudicate? How would you apply when you have to argue the matter? And it has to be some sense of justice, etc. So there will be so many other factors. Now, assuming a tenant is coming and asking for an amendment at the stage when the matter is in the fag end, you scrutinize it a little higher, because the moment you should notice there is some interim, and for 5 years the landlord's petition would be delayed. Obviously, the necessity principle is the first principle, but then the due diligence principle is also there. So if you're a good lawyer or a good judge, or you want to do justice between parties, then you'll be able to find out whether it is super necessary or not. So that factor that is a tenant or not, or the factor that is a plaintiff and not in possession or in possession, or the factor that is a plaintiff and is an injunction in his favor. If he has an injunction in his favor, you look at it differently. If he is a defendant who's coming to delay the proceeding of suit for possession, you look at differently. If he is a plaintiff not in possession and it is his suit for specific formants, you look at differently. So somebody comes up and says, oh no, I've got a judgment on this point. This is where you feel a little disheartened. You have to read from the top. Invariably, when it has been allowed at the last stage, it is the landlord's petition. Because landlord by delay would not really help him. There is nothing malafide in bringing out an amendment. So that's where your advocacy comes in. That's why I say you have to assimilate all facts. There is no judgment given in the abstract. So once you assimilate all the facts and you see the entire judgment, you'll come to know, oh no, this is not relevant in my case. Although I'm not finding anything, so I need to cite it. Landlord ki allow ki hui hai fag end pe. I'm just giving you a small example. Where at the final stage he says, oh, by mistake I missed out some premises for eviction. Now you don't want that the case should be rejected at the stage just because of a technical fault. But similarly, tenant coming up at the fag end, you look at it with all suspicion, you look at it with all, because it's going to delay the proceeding a lot. So this was primarily on the individual facts, matters which will come up as a youngster, that you need to go about, need to know the facts of your case very well and need to understand the judgment very well. Now the second facet is that judgments which are having far-reaching effects, judgment which are interpreting some provisions of law, judgment which are laying down some law which, at least for the time till the time they are reversed, or maybe by a larger bench by the higher court, would stay as good law. Now, everybody must have some kind of a routine in which whatever comes up, you read those judgments. Now, when you read those judgments, find out a time when you're completely at peace with yourself. Normally, if somebody is a morning person can maybe at 6 o'clock one is there. There's nothing as no phone call coming, because once you read a judgment and you don't read it carefully, you would normally never end up reading a second time. Knock it off the first time and knock it off with full sense of understanding. When you're all, I think the understanding, the environment is such that it is very, very good for you to read. Now, in that also I wanted to share this with you, that assuming a judgment is considering a particular provision of law, interpreting it, and then laying down as to how that provision is to be read. First, read the provision. As a student, you have to mug up provisions. The example that I always give is assuming list pendants is there. I again would give that example because it's a very easy. Section 52 of the Transfer of Property Act. And so if there is any sale that takes place, now how do I understand a provision? Just do I see it for 1 minute? We were told that if any judgment you're reading, 100 judgment, even if you read that provision 100 times, before reading that judgment which is going to lay down law, don't read the provision again. Go back to the provision, because now you are enriching yourself in understanding a judgment which is going to maybe carry on for the next a decade or maybe more than that. Any wrong understanding of it will mess up your argument, will mess up your understanding, will make you argue wrongly. Any correct understanding will help you insist the court. So when you read the provision, always exemplify. I used to spend 5 minutes after reading a provision and exemplify to myself as to how practically I would apply it. Now, list pendants principle is there. Reading it with third-party objection. This is how I always correlate two provisions in execution, third-party objection in execution. So, I used to think about it, and I used to exemplify to myself that if my sale deed is 7th of September and the suit is filed on 8th of September, then the sale is not lis pendens. Then the person who has filed the case has missed out on the necessary party, because the sale has already taken place 1 day prior. A registered document is deemed notice. He should have made that person a party to whom it has been sold. If he has not made him a party and he carries on with his suit ultimately will fail unless he amends it, etc., etc. How much difference? So I tell myself, okay, if the sale is 7th of September, suit is filed on 8th of September. On 8th of September, the plaintiff does not know that it has been sold. That's irrelevant. The defendant obviously does not know because he has not received notice. The person who's purchased does not know because there's not even a notice in the suit. Now another situation. If the sale is of 9th of September and 8th of September is the suit, it is doctrine of lis pendens. So again, irrespective of the fact whether the person who's sold it does not know about the case, the person who's purchased it is so-called bona fide. He can never be a bona fide purchaser. He's a lis pendens purchaser. So that's how I put to myself. I always exemplify before reading a judgment, after reading a provision, how will it apply? I'm now a lawyer, I'm now a judge, I'm not a student anymore. I don't need to ratify the line that or learn it by heart. So once I put 3-4 more examples. Now, side by side with this, before I tell you how the judgment I used to at least read and remember for good time, whatever, is that there's a third party eviction. Do you all understand what is third party evictions? You understand? You not. So, third party eviction, you understand? Yes. Because our youngsters seem to be the grave confusion about those third parties. See, third party, what happens is A files the case against B for possession. A wins the case against B. So then he has to execute the decree. When he has to execute the decree, he'll get possession from B. B comes up and files objections, invariably they will be dismissed because he's already lost the case. Now there's a third party who gets up. And why am I saying I'm taking forward the principle of lis pendens? The third party gets up and says, look here, I am objecting because I am in possession. And you got a decree against B. I don't know who's B. So please get my third party objection decided properly. Or you could also say that I am the owner. Now, the moot point is the third person who has come in. See, people take him as a third party because he's a third party. But what would be his right as a third party? We have to relate it back to the lis pendens principle. Now, supposing this C has a sale deed prior to the suit, as I gave you the first example, he is that person who is the 7th of September purchaser. Now, decree is there against B. He will come up and say that prior to the filing of the suit, I had this right. And those third parties will succeed. He will win. That decree cannot be executed against him. Because good luck, bad luck, plaintiff never paid him. Purposely or without purpose, you do not know. Maybe out of inadvertence he did not pay. So that third party has a full right, and that in execution, that's where Order 21, Rule 97 comes in. That is a third party prior to the suit. So he wins. Now there is a third party who is able to show that you filed a suit of possession on 8th of September. This document clinchingly proves that I am in possession on 7th of September. Again, he has to win. Now there is another situation, third party. His sale deed is 9th of September. He comes up and says, I am a third party. But my sale is after the suit. You get nothing.
Yes.
101, 102. Order 21, Rule 102. 102 will hit him. They will say, sorry, you are a lis pendens, you have no right to object. So that's why a lot of people say, why I am also third party? What is my fault? I am bona fide. You can't even raise this, please. And this principle is very well. Why? See, every principle is out of common sense. Why did they give this principle? Lis pendens principle is, if I file a case against you for possession and you sell it to her, then I'll have to file it against her. Then you sell it to her. They say, sorry, you recover it from her. So there are, whatever principles are even in civil law, a lot of common sense. And that's how they have made the third party objections, and the objections have also been made in sync with the basic principles. So they say that, okay, if I file the case against you, you can't make my proceedings negatory just by further illegal act of yours. Maybe the other person doesn't know that she has a right to recover or maybe file criminal case, whatever, against her. Similarly, the third party objection would come in. Hopefully it's not too, we still have time. So similarly, the third party objections come in, and that's how you know, the principles keep. So once before reading a judgment on a particular point, assuming it's on list pendants, assuming it's on order 21, you have, maybe this, chalo, I have a little bit more experience, so I do understand, but you have to tell yourself how do you interpret this by giving yourself actual examples. Don't start reading any big judgment on a point. Judgments are only interpretation of the provision only. And have faith, whether you are 10th pass or you are 12th pass, or you are BA or you are 30 years into practice, you all have the equal sense of understanding on things. English is sabki same hai. You're all from good universities. Have faith in yourself. Even my daughter today does it, I expect that. Then when she'll read a provision, she doesn't need to bug it up. But every word is to be given importance. Every comma will make a difference. Every comma in a provision. So understand the English of it. Apply it by virtue of examples. That's how I understand list pendants. I never forgot about it. But I sometimes ask, I said whether the second sale would be valid or not if the first, if the suit is decreed. Everybody answered no, sir, it will be valid. Doctrine को रटा तो मारा हुआ है, but doctrine को apply किसे करना है पता नहीं. So now coming back to the judgment, how will you read it? If it's judgment given by me or by anybody, you have respect, etc. But don't be overawed. Maybe I have given a wrong judgment. When you are reading a judgment after reading a provision, because that's the judgment which is a judgment on a interpretation of a provision. It could be wrong. You should have the sense of telling yourself, not the court, because sometimes that this is the wrong judgment. Have faith in yourself when you will read it after reading the provision. Anybody can find the judgment is correctly given, or is it making sense, or it's not making sense. And that's how again you start. You start reading with a red pen and a blue pen. You start seeing the pro and the con. Don't jump to the last para straight away. It's a path-breaking judgment. When you repeatedly understand the arguments, you will repeatedly understand what is being argued on one side to interpret that provision, what is being repeatedly argued on the other side. By the time you will reach the end of it, you will understand every word of it. And then, because you have yourself analyzed the provision, maybe there's a very, very important argument which came to your mind, which has never been argued. And because it is not argued, there is some kind of a lacuna left in the judgment. Because after all, judges are also human beings. Whatever is being argued is normally taken into consideration. Now, because you independently thought about something, and you felt that that independent point was a very big point, ये कॉमा देखा नहीं किसी ने, ये फुल स्टॉप देखा नहीं किसी ने. मैंने एक बड़ा इंटरेस्टिंग करा था, अभी एक पहली बार आया है, दिस रेरा, see and how things come up, so many things come up. Now let me, before giving that RERA example, let me give you this Baljeet Singh Bajwa judgment. On NRI. Has anybody read those judgments? Yes. So it's a wonderful judgment. Now how you read a judgment and how carefully you read and how do you come to know. So 13B provisions were interpreted. 18A procedure as to how in a 13B case, which is a special case in a 13A case, is to be dealt with. The tenant needs to move an applicant for leave to contest, and the leave to contest is to be granted on the averments made in the leave to contest. And if now, so the Supreme Court gave a brilliant judgment. Now cases came to us, which on the first phase, I am for a tenant, my leave to contest, either I am not filed a leave to contest. So many situations come up. Or my leave to contest does not say anything material. But now when I study the case, I am able to take out some material point. How do I present the case? How do I apply the judgment in my favor? I can give you examples and examples and examples. But because this is what I have practically done. So there is one paragraph in, I think it's possibly paragraph 25, which, if read in isolation, looks to be in favor of the tenant. And there's one paragraph 19, which again, if read in isolation, looks to be in favor of the landlord. Now what does paragraph 19 say? That any person who comes about, I'm telling you how do you read a judgment, because I read it, I had a lot of work on tenancy, so I read every word of it and I still remember almost every word, how to apply it, how to. So paragraph 19 talks about leave to contest. It says that we will presume that the landlord's petition is bona fidely filed unless the tenant, by virtue of averments made in the leave to contest, supported by material, is able to show that the requirement is not bona fide. So what can you argue from the landlord side is that he has not shown any material. So please don't look at anything else. Leave to contest is not to be granted. He is the plaintiff. If leave to contest is not to be granted, the necessary consequences that eviction order has to follow. Now, para 25 said of the judgment that the moment the NRI proves that he is NRI, comma, he is owner, comma, for 5 years, and it is necessary, eviction should be ordered. Now, somebody could interpret this to say, and that's what I argued in some courts, irrespective of the leave to contest or not, he has to show that he is NRI, he has to show that he is owner, he has to show that. So a question was put to me that Mr. Bahl, once the leave to contest is not filed by you, or the leave to contest does not contain the point that he is not the owner, why should we look at that point? Very valid. The reading of the whole judgment would possibly that it is your leave to contest which is to be seen. Otherwise, we are presuming everything in favor of the NRI landlord. Now, the moment I read that judgment, I thought about it at home. And I knew I will be faced with this question. My leave to contest was useless. And in one case, there was no leave to contest. So I read the judgment and I thought about it that how can I present my case on this point. So what I told, ultimately whether it is accepted or not is a different thing. But the argument should be weighty. So I said this is a benefit given to an NRI. This is how I read the judgment. Para 25 says that he has to prove this. So I said, assuming it's a house number 527 for which he's filed a case. Judge said yes. And the sale deed he produces on record is of 529. There is nothing on the record to show that he's owner of 527. I have not filed leave to contest. Will you give it to him? Now the example I gave, he said, Mr. Bahl, this is an extreme case you're talking about. Let us first understand before we read para 25. Leave to contest not granted, para 19 you go by the other part of the judgment. Obviously, is that you have to ask for the contest. You're not asking for contest. You have filed nothing. So gone. Because that's one way of looking at it. Look at the other way. It's a declaratory suit. And then I gave whatever was given in mind. This is how you develop an argument. From the same judgment, 6-7 lawyers stood up and said, "Not sorry, nothing now. It's come against us, tenant, dismiss. And when I raised this argument, then I said, can I take it forward? I said, yes. I said, it's like a declaratory suit. There's a difference between an injunction suit and a declaratory suit. He said, what is the difference? I said, today I file a case that I am owner of Taj Mahal. And Taj Mahal people are ex parte. Will you grant me the injunction? Will you grant me the declaration? Just because people are ex parte? Yes, in an injunction suit, there is nothing coming from the other side, and I am saying I am in possession, so there is nothing to rebut. Maybe against those persons at least, you might just grant me injunction. So I said 13B is a special right given to a particular person who fulfills those three conditions. It is mandatory for the court to see whether those three conditions are fulfilled or not. And once it is mandatory for the court to see, irrespective of the fact whether it might leave to contest, yes, if it is said there, I can't. If a sale deed is shown, and the sale deed shows that he is owner of 527 for 5 years, I have not put any document to cause any kind of suspicion, then you are right. But if there is nothing, so ultimately, even when the leave to contest is not there, you will have to still examine whether the ingredients are met. Okay, now on this slide, read paragraph 25 of the judgment. The same judgment, I won one matter for the landlord, saying that Lord, he is not filed leave to contest and he just surrendered and he went. He said, Mr. Bahl, just now you argued that. I said, this is what it is. The judgment one read, you can read that same judgment completely in your favor and develop a point. And you can similarly read a judgment and distinguish it completely. And also, so it is that interesting. And in today's world, there's so many law and so many fields and so many, especially civil law, you find it's endless. But even I'm telling you, the judgment which supposedly covers completely everything against you, you'll find out something, and all those matters were admitted. All those tenant matters were admitted. And maybe they are admitted even now. And some are won also, some conceded. कि leave to contest कर दो जी. Because मैंने कहा जी proof तो ऐसे NRI का आया था. But is NRI, what is he produce on record to show NRI? His passport shows that he is born in Pakistan. Pakistan is an exception. So there are so many things we are able to point out and highlight. Otherwise one would say, oh, leave to contest, nothing is mentioned, now I'm gone. Supreme Court also says that, and this is the general view also. So if you read a judgment carefully from the top to the bottom, you analyze it for 2 minutes. You understand it, you go a little deeper. But today also if a case will come to me, I mean if somebody is, whatever law you see, you go a little in depth. You go a little bit in depth. Keep asking questions to yourself. That's when you'll come to know that how many things will open up. If you will not do that, if you will not, then what will happen is you will go by whatever the judgment says. And you'll remember it for 2 days. And the third day you'll again forget. You'll not be able to apply because there will be no case which will come which will have the same facts as the judgment which you have read. अब मैं आपको बता रहा हूँ, there is so much, brother and sisters, so much of thought that it's you love it. I तो love it. I love this profession so much because it satisfies your craving to understand things. अभी पीछे मैं कर रहा हूँ, I am not fully reached that thing. There's something very, because one is not an expert in service law. So there is but I read one full bench. There is such, although I'm taking it a little away, there's a full bench which says limitation, on the aspect of limitation. So there's a full bench which says that if your increment is not paid to you for a particular month, then it's a recurring cause of action. Because every month you're being paid less. So even if you file a case after 10 years, it is within limitation, but the areas you'll get is only 3 years and 2 months. That's the full bench. Now, is there only one facet out of it? There are cases which come up in which you have been punished. And because of the punishment, 2 increments taken away from you. Now somebody applies that full bench who's not understood it fully to say the punishment took place 10 years back, but I can now challenge it because every month if I win that, I'm still, it's the same principle. What is wrong? So what do you people say? There's another situation. I said, okay, let us analyze it. I'm not sure. You can develop as many arguments as you can on one full bench now. Then I said, assuming somebody is dismissed from service, he should also come after 10 years. If the dismissal order is set aside, you will get salary every month. Similarly, on promotional aspects, there are 1 or 2 judgments which came about. I'm just wanting to understand this service applicability of limitation, etc. to service. So very, very interesting. And one would like to give a judgment then ultimately after, or maybe understand after having a broad principle settled in mind. You can't apply something in one case and something in the other case. So there is another principle which said that promotion, if somebody has been promoted, you have to challenge within reasonable time, maybe 6 months, 1 year. Because you have been promoted to the next post. If I sit across for 2 years, 3 years, then you are promoted to the next post. So it's not that I am supposed to come DGP straight away without having to become a SSP. And things will be unsettled. So this is what looks to be the broader principle. But now this person comes, says there are some judgments, some arguments are raised that if you have retired and I filed the case after 20 years, I am only asking for notional benefits. That you were junior to me, I should have been promoted prior. I am not harming you because you have retired. And I just want notional benefits from a back date. So now I can file. So on that, the principle that would come up is that if you had filed it within time, possibly you would have been demoted. And the state only had to pay 1%. So just because you have come after 20 years, would that principle of limitation help you? Just because you have delayed it more. Had you come within 2 years, you would have been barred because the person is working. So this is what it is. So there are a lot of lawyers who very vehemently argue only notional benefits. You have to set down on a principle. The moment you start asking yourself, the moment you start putting on to yourself as to how you should interpret, how you should see a provision, and then go by the judgment what is there and understand the judgment. And assuming you may not agree with the judgment also. As a young person who's 2 years into practice, may also not agree with the judgment, provided you are applied in your own mind. So इसमें अभी ना वो रेरा का भी एक provision है. Very interesting. Some lawyers are, put up such a good point. So there is a RERA provision 43.5, which says that whenever a person has to file an appeal, a builder, a promoter has to file an appeal, then whatever amount has been directed to him to be paid to the allottee, he has to deposit that. So obviously the intent was that these builders are not being fair to the allottees. The allottees file case, they win in one court, and then the promoter unnecessarily files an appeal, delays the proceeds of that entire thing. So they have kept it as a precondition that you deposit the entire amount. Fine? Whatever is ordered in the order. Now there is somebody who highlights that in the same order, it is said that the promoter is at fault and he has to pay 10.5% interest for the delay, which comes out to be 5 lakhs assuming. And in the next line, there is a observation of the same first authority saying that the allottee will pay the balance after 5 lakhs. So in the same order, the net result would be that actually the allottee has to pay to them, but the order is against the person. So there's somebody now, lawyers are also intelligent. He said, sir, take the final order. Why are you taking the one line which is against, the whole judgment is against the person? He says that how he builds up the argument. That the intent is that I should not run away. The intent is that I should deposit the money so that if I lose the appeal, he should be secured. Now once as per the order, actually I have to be paid money. Please ask him. Still something is outstanding. 5 lakh rupees I have to pay him interest, but he has to pay me another 50 lakhs, which are the outstanding for the next installments. So he is protected. The other side argument is, no, this was that so that he does not have unnecessary litigation. He stops it, and it's on a principle of money decree. Money decree is not irreparable, so you should deposit. So wonderful. So in every fact situation, a same provision, so you need to keep going back to the provision. Deposit the entire amount which has been ordered by the same order. Now by the same order, he is interpreting that to say कि I have to be given money back. So where's the question of my depositing? इतना आपको interesting मिलेगा. पहले provision को जरूर देखो. See the provision and then read the judgment. And I'm telling you, each one of you, do that tomorrow, do that day after. Find out the best of judgments. You'll be able to say, no, I don't agree this part, I don't agree. You'll be able to understand the judgment. You'll be able to say, okay, this argument. Now you'll be able to also say that a particular judgment may not be on a particular point because there's one very important argument missed. There's one very important issue missed out. This is the other thing, that a judgment is only a judgment on a point which is argued and debated there. If it's not argued and debated, so whether that would be on that point, assuming this 53.5 is never brought to the notice of the court or is never debated, and the court holds that even 50% is enough. Now somebody would cite that to say that 50% is enough. It's not considered the basic provision. So a judgment would only be a judgment on a point which has been discussed, debated, and then answered for binding precedent also. So, I mean, one can go on and on and on, but the basic thing that I come back to is for all of you, invest in a judgment. Don't think that I am reading it, I have a case, I have to, or this judgment my senior has asked me to read it. I just have to go and vomit it for 5 minutes, learn it by heart, and then go and say, so para 20 says this, para 27 says para 7, and I have said it, and that's the end of it. That one judgment is going to add one feather in your personality, is going to make you understand one aspect of our legal profession, is going to help you in building up that one argument And similarly, this one argument would ultimately make you a wholesome lawyer. So never take, I always used to think that read a judgment for the purpose of fully understanding it. Because as they say, a half understanding of anything is more injurious than, it's better than not to read it only. Because if you know half a thing, you will be worse off on any aspect. I used to travel to Delhi, I was not very good by roads. So whenever any turn would come, I would stop the car and ask him, where do I go? Because I had no knowledge of it. It's better. Another friend of mine who had half knowledge, he would sometimes take us, miss a road, thinking that he would knew where to go, and end up coming back 1 hour back. So whenever you need to read a judgment, understand it. And that's the way I found it is, have a blue pen and a red pen. Because that will keep you alert and active. And whenever you will underline anything, and after you read the whole judgment, come back. If you will not write it on the first page as to what you have found is the culmination of the judgment, then that's gone. If you will try to do it after 1 year, you will have to reread the judgment. Make it your point that once you've read one judgment, more so which is authoritative, you don't need to read it again ever. And you don't need to even see it. You should understand it so well. It's just like we understand how to drive a car. Don't we know that you have to sit, ignition on, brake, this thing. It's not that you have to write it on a piece of paper that way. Because we like it, we are interested in it. So this is how it is. So once you will understand it that way, how will it, and there's a lot of understanding seems to be the profession nowadays. Where is the need to read it? They all know it. They know it, and he is going to do whatever he's going to do ultimately. Or if I'm stuck there, I'll take a date and then I'll read it. This is the general thing that we are now seeing. On the converse, I would say, at a young age with great difficulty you get a case. General reading may sometimes be very general. Generally you're reading judgments, generally you're not applying it, so therefore your lucrative mind is not working. The moment you have a case, search whatever you can search on that. Find out whatever you have. Give it your best shot on the first day. Your client will see you working on that case, judgments that you're reading so much. You go to a doctor and the doctor is looking at your x-rays very carefully. You will go back to the doctor. So read it carefully, and the first day you're presenting it, the judge will also feel that there is somebody who's here. The people at the back will also see that. And your understanding will then ultimately make you feel that now, okay, this is how I need to see this point. And imagine 1 year spent, and I was just telling somebody that 1 year in a profession, 365 days. Even if you take out 65 days, 300 points to learn. And on the other side, if you read facts of a case and leave it there, what's your learning? Assuming you take up to 300 days, count your 1 year as 300 days. You just read the facts of a case, or maybe two cases, and just leave it there. So where is the lawyer in you? How are you becoming a lawyer? Even the client knows the facts of his case. So you are ending it there. Whereas if you pick up 1 point every day, you will by the end of the year know 300 points. And that will serve you well as you go up and as you ultimately become a senior advocate and ultimately adorn the bench. Once you know, people will know. They know the law. He knows the law. She knows the law. And you apply that law to the facts of your case. You still win on the facts of your own case. Anybody who want to, you can.
Thank you so much, sir, for your precious insights. I am intrigued by the fact that there is so much technique involved in the art of judgment reading and applying it to your own facts, because in our academic years we are always taught that in this case it was held at so and so. This is the only thing that we've been taught all this while in our academic years, being freshers, I would say. But it's really heartening to know that there's so much technique involved, and brilliantly you've enlightened us all. I would now request if any questions can come up. The floor is open for questions.
Yes, sir. Go ahead.
So in the brief period of research work that I have taken up till now, I have come across two kinds of judgments. One is a judgment whereby you can easily point out, okay, this is a fact, this is an issue, this is a judgment, this is the reasoning for it. That means that in one go you can point out these 4 or 5 things in clear-cut manner that these are written over here. But then there are certain other judgments which are a bit lengthier judgments in which you have to read again and again to call out, okay, these are the facts, okay, some fact is written in the middle of the judgment as well, and some issue is not clearly written, you have to take out the issue, and then you have to see the judgment and then the reasoning. So in those kinds of judgment, having equal respect for both kinds of writing style, how can we read the latter form of judgment, that means a bit unstructured judgment, in a better way, in a more structured way, so that first of all the time can be saved, and secondly the point that we are looking for and the essence of the law that is discussed in that judgment can be taken out in a bit easier manner. So
You're absolutely right. This is, see, art of judgment writing, now there's a judgment on that also. Sometimes I can say that from a judge's point of view, if you have very thoroughly seen it in detail, you will normally have a habit of writing a little lengthier judgment. Now, when you perceive it from the way the one who's reading it, the one who's reading it would rather want it should be a little crisp and it should be crisp and short. And to exemplify that, I can share this with you. There was one district judge who was one of the best judges in that district. So the Chief Justice of the High Court was his administrative judge. And the Chief Justice went to him and he wrote a judgment. 6-7 days he did not sleep. So he wrote it with all his heart and soul. And he was very happy that the Chief Justice is my administrative judge. I'm going to show that judgment to him. They were supposed to show 5 judgments. So he kept that as the first judgment. And it was a piece of art. So when the Chief Justice was made to read that, he read it. And the other 4 also he read it. So there was no major response. So the judge got very curious as to why I have written such a piece of art, and I was sure that there will be some good reaction. As he was sitting in the car, the chief, so he said, because he became a little disturbed that I have written such a piece of art and there is no. So he also sat along with him. And he said, sir, if you don't mind, can I just ask you one thing? There was something wrong in judgment number 1. So obviously he wanted to extract something out of the. He said, sir, I put my heart and soul. So do you know what the response of the chief was? He said, I would rather want you to decide 20 good cases by writing 20 good judgments instead of deciding 5 cases by writing a poetic judgment. So, or judgment which is too lengthy, or judgment which is too. So therefore, on the first principle, you're absolutely right. As a human being, I can share this with you, I have a habit of writing lengthy judgments. It's only when I as a judge read a couple of orders coming from the district, see how you learn. Sometimes you're in a position nobody ever comes and tells you that this is what you're doing is wrong. Your best friend is the person who will come and tell you, please rectify this. It makes a lot of effort to write a lengthy judgment also. So it's only when I introspected and I was reading an order of a judge, which was very lengthy, then I said, okay, I'll read this in the end. And one was a little bit unhappy because the same things were being repeated again and again. That's when I realized that I need to cut down also a little bit of my judgments. Now, faced with the situation, as you are saying as a student, see now, or maybe somebody who wants to cite it. Citing a judgment, if a judgment, lengthy judgment, has to be read, and it is necessary for a particular case, then in that situation, it has to be read. If there were options of 3-4 judgments, maybe you will choose a judgment which is of equal importance of a Supreme Court and maybe lesser number of pages, so that you're able to understand better and quicker and able to put across easily. But there are some constitutional bench judgments which because they have to consider the earlier law, they have to distinguish, they have to deal with all the arguments. In fact, their judgment very fair to the lawyer. You can cut down the arguments of a lawyer and then maybe make it as crisp and this thing. But if you consider all the arguments, then you have to answer them. In that situation, that's why I said now, when you read the whole judgment, by the end of it, you will be able to come to know that there are these 3 paragraphs, there are 4 or 5 issues which are there. In those 4 or 5 issues, there will be 2 or 3 paragraphs in every issue, which is the crux. Now, there are some brilliant judges who have to write lengthy judgments because of the magnitude of the issue involved and the fact that so many arguments have been raised. But if you see their brilliance, normally in the last part of the judgment, maybe the the culminating paragraph or whatever, they will normally crystallize it also. So when you find a detailed, lengthy judgment being there, although I would advise you to read everything, at your age I don't think so you should skip anything, go to the last first. Go to the last first. Invariably I have seen that in the last, so that's a way of, saving your time. Maybe you still end up reading the whole judgment, but you might as well read the last paragraph, which culminates all the points. Once the points are culminated, and you know that this is the answer given, that's in fact even a better way of reading even the smaller judgment, even the judgments which are not too lengthy. To read the last part, and then to come back to the first, to understand and to see in detail as to what is the last part. There will be judgment with there will be 4 or 5 issues. Go to that issue, maybe read the first paragraph of that issue, and go to the last part. As you read the last paragraph, supposing the last paragraph is also not that crystallized, go to the second last paragraph. Start backward. This is how you do case reading also. See, when you become a little senior, you have paucity of time, you have to read 45 matters in the morning. Although I would never advise you to have those cut shots either while reading a judgment or while reading an impugn order, which you need to ultimately, finally adjudicate. But in every order, in every judgment, there would be arguments of the counsel. There could be arguments of the respondent. Then there would be a finding. So after knowing the issue in hand, you can go to the finding. If it's too lengthy. Rather, in some situation when you are a little more experienced, you will first go to the finding. Because otherwise your brain will overlap with the argument as the finding. This is also another way, a lot of impugn orders are read by some of my younger colleagues, and they come and say that because of this and because of this we have lost the case. Whereas when you actually read the order, that is not the reason given. The reason given is in the last paragraph. But maybe the argument of the other side is taken as a point against, which actually has not been worked with the judge. So you are answering something which is not actually against you. It's only an argument against the person. So maybe with little more experience, now what we do is, we know the issue, maybe read the facts. Facts are always read from the plate of the written statement. Okay, read up to the facts, skip the arguments for a while. I mean, if you feel that, go to the last part of the judgment, go to the finding part. If the finding is also too lengthy, see the initial part and then go to the last part. So that you are able to crystallize in your mind as to what has been held. And once that is crystallized, then you can, I would still request that read the whole judgment. Because maybe it will take that extra time. Maintain your focus to the last. Just like when there is an RSA. A lot of people have the habit of reading the trial court first and then the appellate court. I used to tell all my colleagues, if you want to know the case, read the plaint and the written statement. Don't see the plaint from the judgment or written statement from the judgment. It will stick on to your mind. Assuming para 1, there are 6 paragraphs in a plaint and there are 6 paragraphs in the written statement. You need to correspond with every paragraph. You will stick, okay, he's saying this is admitted. He's saying this is admitted. So you know the gist. Then go to the appellate court's finding. Because the assuming trial court has held 4 points against you, but the appellate court has held only 2 points. So the other 2 is then, for the purpose of that case, is a waste of exercise. You need to just solve those 2 points to win the matter. 2 points have been dealt against. If somebody files a cross appeal, you'll see that. So you go to the last first, and then read everything. It's not that at your age you'll skip anything. You'll not even skip one piece of evidence. You'll not skip even, forget about the judgment, you'll not skip anything. In a detailed judgment, rather slowly when you see, even when something is not too detailed, I don't want to say this at the beginning. What we do today is, we see that maybe the catchwords, we find that it is relevant. Just read the first paragraph for the time being. Because assuming you read the whole and then you find it's irrelevant, you can't, sometimes you don't have that much of time. You come to the paragraph which have been highlighted for that proposition, maybe paragraph 30, 32. So you read 30 to 32 and you find, no, this looks to be on the point. The moment, because saving your time is also another thing that you will slowly have to buy and buy. Maybe as a younger colleague also somebody gives you 3 hours to get a judgment. So you can't spend the 3 hours on the first judgment, which ultimately you find is completely irrelevant. So you go to the important paragraphs, which lay down that part of the law, paragraph 30 to 32 maybe. And then, you find, now there was a proposition that I was just, somebody was arguing as to up to what time the counterclaim can be filed. I never dealt with such a point. So, a lot of discussion was there. There were separate judgments given by two judges. But the lawyer from the respondent side was very good. He said, please come to the paragraph 40. Now, for a judge to be spending 40 paragraphs on the dais would be, spending quite a lot of time. So, we came to the last paragraph, 40th paragraph, that said that it's up to the issues that a counterclaim can be filed. So, that was the crux. Now, to have a better understanding of judgment as to why he said so, then you can read the whole judgment. So, you come to try to see it from somewhere in the end as to where the crux of the judgment is. And one does hope, and normally it does follow, that in these super lengthy judgments, there is something in the end which is mentioned. And assuming it is not crystallized in the end, then under that particular issue, 4-5 issues are being decided, this is the last 2-3 paragraphs. So that's how you will come to know. And once you are sure as to, because when you are reading, if you are not sure what has been held in the end, then your mind is too wavering. And if it's a very difficult constitutional proposition, you are not able to. Once your mind is set that this is what it is, that's why I say, see the X-ray first. और उसमें मैंने एक principal को बताया था. A lot of people come to engage you, they don't even know what is the reason why you lost the case. It's just like a doctor not knowing what the problem is. So I told them that to be successful, to be able to win a matter, to be able to show that the matter is good, you will have to first know where the problem is. So somebody come and say he's got some problem somewhere in the chest. Somebody come and say no, he's got it in the heart. Somebody say he's got it on the left ventricle of the heart. Maybe little chance. Somebody say it is on the left ventricle at 25 centimeters on this point at the back. He's the person who can solve the case because he knows the problem. So वो review order में होता है, वो judgment में होता है. तो आप उसको, if you find that it's too lengthy and you like to read it, read the last part of it first. And in some of the judgments, you know not to argue, even the last part will be suffice. Normally दिया होता है कि ये सब कुछ है. This is what they're crystallizing.
Thank you so much for
So that's all. Yes, sure, go ahead.
Sir, I am stuck in one issue regarding time management, which I am pretty sure many lawyers face this issue. Now, what happened is, as youngsters, we are attached with the senior lawyers. Plus, we also practice at our personal cases. So, Lordship, what happens is that sometimes we feel like that we have done full research on that case, but we are getting nothing on that case. So, I want to ask that where to stop. That yes, that we have to give time to other cases also. Sometimes what happens is that many cases are listed on that particular day, and some cases are allotted to us by our seniors, like 2-3 cases. Now where to stop that yes, I have done with this case, I am getting nothing, and I have to move to next case so that I can do well on that case.
Very good. See, now the thing is, the toughest period for all my younger colleagues is a period when you are working with a senior. After that, you have a lot of time. Even if you have good amount of work, you will have time for yourself. You'll be able to plan it the way you want to plan it. That is the stage when you do not know too much of law. When you do not even know whether you'll be made to argue the matter or not. So it's a situation where sometimes you come a little disheartened also. But that is I think in every profession, the beginning is the toughest. So now, how do you manage your time? Now, the first thing that the office that we were working in is to be given 7-8 cases each to be seen. So first thing that you need to see is as to whether the case is for arguments or not. So you used to pick up a file, you used to see there how many respondents. See if it's not for arguments, just know in that case for that 5-7 minutes you need to spend who's the respondent, who is left, the one who's left is a necessary party or not. Is there a stay in our favor? Is the stay till the next date? Or the stay is in the meanwhile? Are we in a hurry or not? So once you spend 7-8 minutes on that and it's not for arguments, you can keep it on one side. Pick up the second matter. Again, see whether it's for arguments or not. The moment you find that the case is for arguments and your senior would in all probability will be arguing that and you'll be asking, put it on the left hand side. Pick up the third file, depending on the number of matters given to you. If it is not for arguments, know what is to be done in that, process fees to be filed, who missed out, clerk, etc. Spend 5-7-10 minutes, put it on one side. Now pick up the one which is for arguments. हमारे कहीं पहले आते थे तो first case only they should start reading because this is where time management is. And I can tell you how I used to go further and as I became a senior. So then, because our senior had a lot of work, That's how 7, 8 cases to come. So we used to, the one which is to be argued, we used to threadbare see it. If you have to check up the law on that, see, law is now, that all I can say is that, according to me, whatever I've seen in the profession, till the time you're not getting up at 4:35 in the morning, I don't really, because see, as a judge now, we come back at 7:30. There are 40 urgents. If I don't read them, then I am at the, I don't think so one can really do full justice. That's my understanding. Maybe somebody may be catching up the files very quickly. So you have to get up at 4:30 in the morning. As a younger lawyer, as you're saying, whatever time I would get for myself was only the time, 3 hours in the morning. As a senior counsel, when people will come to brief you, then also it's at 5 o'clock, because they'll keep telling you the case, but you realize that's not the correct. So you will have to, or maybe you have to prepare the argument in the morning. So at no stage, as a lawyer, I found that I could do work, or even as a judge, if I don't get up at 4:30. That's, see, some people work at night. Now people in Bombay work at night. That's your call. There has to be either a 9 to 2 o'clock. There are some Supreme Court judges which I know, they work from 9 to 3 at night. So that much of time, now you see 4 hours of time, of independent time you need to maybe work for law. You can't find out law in 1 hour. Howsoever good you, unless you've done so many cases that you know, okay, this judgment from there, this judgment from there. You can ask them in the morning, there are 10 judgments, out of the 40 cases that I read, I take out 10 judgments today also. It's my colleagues who take out the judgment, so that I can assist there's some in their favor also. There's some against, obviously. So that I can assist them in filing, because they will not get some law. But you need to cite that law in order to finally adjudicate the case. So the moment you will give that morning time to yourself, then what happens is, see, this much you need to plan with your senior. A case which is there simply because you have to appear there and take a date is a different thing than from a case which you have to prepare, maybe a draft. For that, anybody would need 4 days. I used to give at least 4 days to my colleagues. And then also see to it that they get enough time. Everybody can't get up at 4:35. So what I used to do is that I had to put 2 people in the case and maybe give them a little bit time, a little bit off, because I had 15 younger colleagues with me. But if you don't have that, and you have to appear in the court also, you will have to find out time, maybe sitting in the court next to you. वो जो थोड़ा कॉफ़ी का टाइम है, वो उधर का जो टाइम है, बाहर घूमने का टाइम है, वो निकाल दो. Because in the court, and I can tell you, my brother-in-law, Mr. Nidesh Gupta, is a senior advocate in Delhi. I was shocked. Once he was carrying the files, and the matter was the next matter. He come for a matter in the High Court. Look at how much time we can save. So he was reading the matter, and I was very surprised because he was so well prepared in the matter, I thought. So I just asked him, why are you reading this case, brother, again? He said, no, this is not this matter. This is the next day's matters. So his matter was next, which he had already prepared. For the next day's matter, he was preparing while sitting in the court. That's how you save your time. And that's what our office started doing. We used to keep all the files in a vacant court. Everybody knew that court number 14 today is vacant. So all my files for the next day, and all the 15 colleagues, all of them used to come at some time or the other and prepare their cases for the next day. You have to save time. If you feel that 10 to 4, how much time do you actually spend arguing a matter? Maybe half an hour. Somebody is very busy, is maybe spending 2 hours. The rest of the time you're just whiling away. You can't just come back at 5:30 and think that you're going to, in 3 hours, knock off your work. It has to be a time management, and this is what we used to do. We used to have 30 matters in a day. All my younger colleagues, and that's why God bless them, they're doing so well. There was always a vacant court text, because you can't sit too far away also. All the briefs of the next day were brought, all the briefs which were being prepared in the case, because they had to show it to me also. So I would not have time in the evening. So every time when somebody would come, sir, I have seen that, you have 10 minutes. So I used to go and 10 minutes, and they used to take guidance also repeatedly. So they were working at that time in the High Court. They would rarely go for coffee, rarely go out in the lawn, spend their energy, and 60% of the work is to be done in the court itself. And obviously then followed up. Now, assuming, brother, I am telling you, maybe there's one more stage will come, God bless you, should come. When you don't have too many juniors, younger colleagues, but you have enough work. You have to draft one case every day at least. Your steno will come at 5 o'clock. Now you at that age can't afford to keep a steno for 24 hours. So if it comes at 5 o'clock and he says I have to go back by 7:30 or 7 o'clock, and if you start preparing the case for drafting at 5 o'clock, You would prepare it by 6:30. So when will you, the fellow will go? You'll have to prepare it sometime in the court working hours. And you should not be missing from the court also. I've seen a lot of youngsters now, they take their day off. You should be seen in the court. Why can't we work in the court only? Side pe there are so many courtrooms which are vacant. At least at our time, we should do that all the time. I saw my brother doing it. And he's one of the top lawyers in Delhi. So we borrowed that, ki why should actually be waste? Justice Palli's office used to sometime be. And I used to see Mr. Mahajan's office, all ones who are hardworking, you could see, unke bhi fayde pade uthi. So you will knock off, imagine how many hours you have in the court. Whatever, there's a library, then you have laptops. You keep searching. Because I'm very happy that you're finding that there is time constraint. There is time constraint. There's no doubt about it. और वो जो cases जहाँ पे तैयारी करते हैं ना, थोड़ा सा see the initial material that you'll get. First case comes to you for specific formants or anything. In the impugned order, there will be 5 or 6 judgments. How we started, because at that time there were no laptops to find it out so quickly. So we used to find out the judgments from the impugned order. Put the one on the favor on one side, put the against on the other side. Make the heading, limitation पे ये है, ready illness पे ये है, favor ये है, against ये है. लगा limitation का point ना जरूरी नहीं है, जरूरी था first read ready illness. Ready illness में नहीं Supreme Court. From one judgment you will get another judgment. Because the one which will be cited will be invariably relevant. Slowly, some guidance somewhere. Please read the judgment, see that judgment. But judgment you should read yourself. Somebody may help you in getting to a judgment. Somebody may advise you. There's something like that. Because finding sometimes takes time. But the moment you get that judgment which is relevant, don't leave it. Get up at 5 o'clock, get it. Don't leave it for the next day. वो उसी time पे खत्म करो उसको. Anybody else
Before
also?
proceeding to conclude, do we have any other questions? Last question we can have.
So there is one critical question about the ad valorem fees in which Devbrat, State of Punjab versus Devbrat Sharma decided this matter by the Supreme Court that in cases where there is monetary claim, so the amount of monetary claim, the ad valorem fees has to be paid. But when a case is structured in a way, a plaintiff is drafted in a way cleverly that a mandatory injunction suit and incidental relief of the monetary claim. So how to present such kind of cases in front of the court and interpret that judgment in our favor?
See, I can tell you the court fee issue is possibly the issue which is the most, I would say, confusing for our brothers. Because nobody, according to whatever I have seen people appearing, they straight away go to a judgment. Nobody has read that section 7, 4 and 5. And on every basic aspect. Now, before I tell you about two things, one is, now a person is to file a suit for possession because you are in possession. I am going on first principle again. And he filed a suit for mandatory injunction to avoid court fee. By the end of it, can the court say, sorry, you should have asked for possession, you are filing for mandatory injunction. And therefore, this is clever drafting. I will lift the wheel and that's one way of looking at it. And I'll ask you to give suit for, pay the court fee for the correct suit that should have been filed. The other is, he's risking it. He's filed a suit of mandatory injunction. He says, I'm going to file mandatory injunction only. It's a trespasser who's there from whom I'm wanting possession. I'm not wanting possession from a licensee. So this is my suit. So now the question is, why as a defendant, just to get court fee, I have not been able to understand. Why will you oppose it? Because that's why there's some judgment say court fees between the court and the plaintiff. And the defendant has no right to agitate. That's my judgments also say. The reason why I say so is, although it's a court fee, is a point given under Order 7, Rule 11 for rejection. But I say, as a defendant, your bigger concern is to win the case, or your bigger concern is that the man should pay the court fee. So whenever a defendant comes, in 227, are we supposed to interfere? At least, I feel there is a wastage of litigation. It's between the court, so that's the first principle. A person has filed a wrong suit by supposedly cleverly drafting. don't give him the relief. Because mandatory injunction is only to be given in case if the person is a licensee. Now that's on that first principle. The second thing that I feel is complete before I come to the compensation part and the monetary part. The second thing which I feel that is being completely misunderstood. Sardul judgment has come on the court fee aspect. Now, the principle is very simple. If I am a party to the sale deed, you understand that? That point you understand? Now I can give you the logic behind it. Everything has logic behind it. I sell the property to you, and then I come up with a suit to say that there was a pistol on my head, that you played fraud. Actually, I signed something else, I signed something else. Invariably, no, these are all false pleas. These are pleas in the air. So they say, you're a party to the sale deed, please have ad valorem court fee. On the other side, I say that this property belongs to my father, or this is my house, she has sold it to you. Oh, what is my fault? So they say, please don't pay court fee. But I have to show my independent right. Similarly, if I say it's coming from my forefathers, my father had no right to sell it, at least to my extent, share. The Ranjan Singh judgment full bench. So there's a logic behind it. Now comes the... So therefore, where is the defendant? In any case, it's between the court and this thing. So they say, why is the defendant so agitated about it? And why is he delaying the whole situation? Then obviously other judgments came that even if you ask for amendment, mandatory injunction is also like specific formants. You pay court fee, that's good enough. There are 3-4 judgments on that. On the compensation part, invariably the good judges will pass this order that whenever I am finally deciding as to how much money I have to pay, I will make it conditional. See, that's, you have to examine what order is being passed. Whenever such a suit is made, and it is made in a manner that cleverly the amount is not being crystallized. So when the best order I think the court can pass in that situation is that if I am about to give him 10 lakh rupees, then I will ask him to first deposit that court fee. That is substantial justice, because why should the person who's asked for 1 crore in a way, in damages or something compensatory, which he may never get, should be asked to pay court fee on that? The other is, why should he then, scare the defendant so much without having paid court fee? But then the question is that, looking at why the defendant is so worried about it, it is the court fee is the court, because you are wasting the court's time. So it is for that reason. A deposit under 43(5) is completely your right as a lottery, because you get the money. Court fee you're not going to get. So I don't even entertain. On first principle, and that's the reason. The other is that as far as the clever drafting part is concerned, the best it can rest, according to me, is if somebody says that I can't crystallize it today, you please see what you can do by the end of it. And the court ultimately feels that 10 lakh is what we're going to grant him on the basis of compensation, damages, etc., maybe defamation, whatever. And at that time, we'll tell him to deposit 20,000 rupees. So where is the unfairness in that? We don't want that unnecessarily something should be abstracted out of him. If he has a genuine case, maybe he has a genuine case that he's been harmed. But it is to what level he's been harmed, he can't assess. So for recovery, I can assess, you've taken 20 lakhs from me, that you have to give me 20 lakhs, agreement says double, I can assess that. I do not know, in my understanding it could be 1 crore, but in the court's understanding it could be just 10 lakhs. So therefore, as a defendant, I can't even now, because my view on this is that 227 is not meant for all this. We can't be roadblocks to the cases which are being, and you read the judgment on 227. It's the court, trial court, which assesses, it's a court fee which has to be paid. So it's nothing going to come in the pocket of the defendant. And sometimes, I feel very surprised. That case, the one judgment I've given on KLB builders, you just read that. A suit is filed against a builder. It files a suit for mandatory injunction. There's an agreement, he says. Now, what is the concern of a true, if a person is a builder, he would feel that if he gets an injunction tomorrow against me, I have to sell the property to a lot of people. How do I then, what will I do if he sells these properties to people? That could be the concern. And what you would want is that let this suit continue. It's a kind of not the best suit that is filed. Why should I come and bring an objection? An intelligent lawyer on the defendant side, respondent side, he should be quiet. If the judge is not agreeing with just be quiet. If he's filed the wrong suit, don't guide him. What we will do is, we'll guide him. No, he's not paid for court fee. He's not asked for specific formats. And the fellow says, okay, sorry, and the court says, no, you do it, and he does it. And it is still within limitation. Now the chances of getting injunction is much higher. Had you kept quiet, 3 years would have gone by. Your main concern is injunction. You would have never got injunction. So just to get court fee out of him, now you're going to suffer an injunction. Because now he filed the correct case. So agar 3 saal nikal jate, the amendment would not have been allowed. So as a defendant, you don't have to oppose it just for the heck of opposing it. But obviously, as a youngster, when you're getting matters, you have to agitate the matter further. So obviously, you will if you have to argue it, then I want to only say that it's a clever way of drafting. And judgments will find on both sides. That you need to lift the wheel, you need to see this. But as I see it, as a defendant counsel, I would tell my client, brother, if he's filed a long suit and he can't get the final relief, even if ultimately proves that I'm a trespasser, I would rather let him file the mandatory injunction, rather to get court fee, to get him converted into a suit for possession and then kill myself. वो compensation में बात आपकी ठीक है, इसमें बहुत debate है. But so everywhere you have to realize that it's not it's the larger victory that you have to get for your client. It's not the small issues that you need to win on. But वो ये ना वो revision आ गई है, वो नीचे कहते कर दो. Why tell the other person that your suit is wrong? Order 7 Rule 11 is the most misused provision. They keep telling you कोर्ट फी गलत है जी, आपका सूट गलत है. वो कहता अच्छा जी ठीक है मैं कर देता हूँ, स्पेसिफिक फॉर्म में डाल दिया और कोर्ट फी डाल दी. अब इंजेक्शन मिलने का चांस पूरा हो गया. अब अगर आप बिल्डर को कह दो जी यू कांट सेल द फ्लैट, वो तो मर गया. अब यही 39(1) आर्ग्यू होता विद द मैंडेटरी इंजंक्शन सूट विदाउट कोर्ट फी, यू वुड हैव नेवर गॉट द इंजंक्शन. आई मीन देयर वर वेरी चांसेस ऑफ गेटिंग एन इंजंक्शन. सो यू हैव टू लुक एट द लार्जर पिक्चर, द वंस हु आर इन द ट्रायल, but they look at the smaller picture.
Thank you so much, sir, for your precious time. I would have to admit that the red pen and the blue pen technique, as also the mind-blowing legal analysis that goes behind reading a judgment, is something that all of us, and for all the others who will be watching this video, it's something we are all going to keep in our mind whenever we are going to approach any judgment. I would like to proceed with the vote of thanks. I would, on behalf of the Vidhi Talks, I would extend a heartfelt thank you to everybody, all the participants who have also spared out their precious time for this valuable discussion, and our deepest gratitude to Justice Vikas Bahl, who has been very kind to spare out his precious time. I would also like to thank Vidhi Talks initiative, which is a purely academic and a brilliant initiative aimed at fostering a harmonious relationship between the bar and the bench. And I would extend my gratitude to Mr. Suveer Sidhu sir, who has been very kind in reposing his confidence on me to enable me to organize this event. Thank you so much, sir.
Thank you. God bless all of you. And thank you for giving me this opportunity to be able to interact with all you youngsters. And oh, this is the pen that I have. So this is the one. It's got a blue and it's got a red. If you can keep 2 of them, that's very good. But then you don't need to really repeatedly. That's how I've been doing it all my life. And chalo, I hope all of you do very well in life, and you would see from the way you've been interacting.
Thank you so much.
God bless you all. God bless you, and thank you for giving me the opportunity.
Thank you, sir.